That's fine.
All right. Judge, the,
Move that mic a little bit closer to you,
Yes,
please.
ma'am.
Thank you.
turn it on.
Turn it on, move it closer to you. Thank you.
All right, Judge, just want to start by saying the law doesn't reward people for disposing of the bodies of their murder victims. The case law is clear that the state does not have to prove how Mr. Simpson murdered Suzanne Simpson. What we do have to prove is that he intended to cause either her death or serious bodily injury, and that he did in fact cause her death. And I won't belabor that point because it's addressed fully in the state's brief, which was filed on April 1st of this year, and I'll just ask the court to take judicial notice of that brief, which is part of the record in this case. But to just sum up, the manner, means, the how of committing murder or assault are not elements of those crimes. But when we allege an unknown manner and means, we've done more than is required by law. The law doesn't even require us to put that in the indictment. Those are not elements of the offense. We're not required to prove them. The state's indictment tracks the statutory language for each offense, and it gives adequate notice of each offense charge. We've alleged intent, and we've alleged result. We don't have the benefit of a body at this point for a medical examiner to look at and give us a precise cause of death, but that does not prohibit prosecution of this case. I want to take a moment to address the specific points that the defendant makes in his brief that was filed on Sunday. And first I want to note that the defense seems to have waived any argument with respect to paragraph A of the murder charge and the other charges in this case. It looks like at this point we're only arguing about paragraph B, which is the act clearly dangerous to human life part of the murder charge. So in his brief...
Was that accurate?
That is correct, Judge. I can respect that under paragraph A, under the right circumstances, the state can proceed.
Okay.
So in his brief, he gives a general statement that tracking the statutory language isn't always sufficient, but what's not clear in the brief, in my opinion, is that this statement only applies in certain situations. And it was up there, actually, in the language that he had, that the situations where that applies are when you have a conduct-oriented offense, which murder is not, and also when there are multiple different ways of committing that offense that are outlined in the statute. That's where that applies. And the case law says that very clearly in the case that you cited. One example that I can give the court is sexual assault. So in sexual assault, which is a conduct-oriented offense, it's about what the defendant did, not the result of the offense, as in murder. And if you look at the sexual assault statute, it says if the defendant did intentionally or knowingly, and then it has A, B, C, D, different ways of committing that offense. And that is the sort of thing that what Mr. Gilmore cited is referring to, where you have both a conduct-oriented offense and statutorily defined alternate ways of committing that offense. That is when we have to plead specifically which one of those we're going to prove. That's what that language is talking about. So it doesn't apply to this case. Sexual assault, again, conduct-oriented. The gravamen of the crime is the act committed by the defendant. Murder, the gravamen is the result. It's the death that is caused. So that's the type of statute that requires that additional specificity in the pleadings. And we do, in sexual assault indictments, we do have that specific, like, it was committed in this way. The statute in this case is not like that. There are no multiple ways listed. That act clearly dangerous to human life is just an element. There's no alternate ways listed in the statute to commit an act clearly dangerous to human life. What the case law that Mr. Gilmore cited doesn't say that every term that's undefined in the statute has to be pled specifically. It's just talking about those specific situations. So it just doesn't apply to this case. So there's really two reasons. It's not conduct-based, and there aren't options listed in the statute. So that argument really does not apply. And when it comes down to it, Judge, defendant's argument, he claims it's about notice, but it's really about sufficiency of the evidence. What he is saying, I believe, is that we have that element, okay, it's an additional element in paragraph B of an act clearly dangerous to human life, and he's asking, well, what evidence do we have of that? And that is a sufficiency argument. It's not appropriate for a motion to quash. That's a trial issue, so it's premature to be addressing that now. And that element, the same as the manner of means, Judge, it's too early to make that decision. So I'm asking you, Judge, for those reasons to deny his motion to quash, and for the reasons outlined in the state's brief as well.
And to you, Counselor, what about the idea that the state can only give you notice of what they know? In this case, apparently, I'm assuming that through your representations, there is no body of the, complainant in this alleged offense. What do you say that the idea that the state can only give you notice of what they know?
Sure, and so take that to its logical conclusions. What other offenses could they indict Mr. Simpson for that they think they know about and they hope they produce evidence of at trial? I mean, what offenses could they indict anyone for that they don't know about now and aren't telling me about, especially in an indictment, but they sure hope to shore that up by the time we get in front of the jury? I mean, ultimately, Judge.
Well, when you say that, when you say shore up,
Mhm.
let's say, and I know this is an alleged offense, but let's say at some point the body of this individual, this complainant, is found, then they would have to give you more notice, correct? I mean, when you say shore up, is that what you're talking about?
Well, so in a hypothetical situation where something like that occurred, I would expect the state to either amend or re-indict.
And
right?
so would I,
There would now be new facts, and there would be a medical examiner's report that would allege cause and manner of death as well.
But I'm trying to figure out what you meant by when you said that they can shore up their case as they go. What do you mean by that?
Well, I mean, the state will, I'm sure, agree with me that discovery is not complete in this case, that they're still awaiting on at least 6 reports for the Texas Rangers that I'm aware of.
Okay.
And so the state is hoping that additional better evidence will appear in those reports. As of right now, I don't want to get into the sufficiency because it's not an issue here.
Well, then that's the next question. What's your response to the state's argument that this is really a sufficiency of the evidence argument and it's not ripe right now?
Well, I mean, it's just not. So when the state was talking about the sexual assault statute, right, it listed all the different statutory ways of committing the offense. Well, I mean, that's exactly what we're dealing with here. 1902b1 is one way the person can commit murder. 1902b2 is another way, and then 1902b3 is felony murder. Then there's capital murder. There are other statutory ways of committing murder, right? And I've already agreed that under the right circumstances, the state could proceed in a manner and means unknown 1902b1 murder. I mean, that just from my research, I've seen that it's appropriate to do. But 1902b2 has different pleading requirements.
But where do you get that? From the concurring from the concurring opinion in Lugo?
No, from DePaul versus State, which says it
From
explicitly.
the what, I'm sorry?
DePaul, D-E-P-A-U-W.
And I read a lot of these cases, but tell me what that one says.
Sure, and that was in the PowerPoint, which I can supplement with a hard
Just
copy of. But
summarize for me, please.
It's 658 Southwest 2nd, 628 at Penn Site 633, out of Amarillo in 1983. Petition was refused, and that case says explicitly. On the other hand, 1902b2 imposes a requirement upon the state, which section 1902b1 does not, namely that the state must allege and prove that the accused committed an act which is clearly dangerous to human life. Therefore, we believe the cases cited by appellee, which hold that an indictment is valid even though the means of the murder are not alleged in an indictment, are an opposite to 1902b2 case. So it's saying you can do it in a 1902b1 type murder. That a person knowingly, intentionally killed another person by manner or means unknown to the grand jury. All the opinions I've read say that they can do it that way. But DePaul says explicitly, and I omitted the citations from the PowerPoint slide, but it cites to other cases for similar proposition, that for the purposes of 1902b2, if they're going to allege an act clearly dangerous to human life, they've got to give me some kind of notice of what that act is. More to the point, how did the grand jury know that it was an act clearly dangerous to human life if they didn't know what it was? Because there are conceivable acts which could result in a person's death which weren't clearly dangerous to human life. And in order for me to test that at trial, I would need to know ahead of time what act the state is alleging he committed. And so ruling in defense favor on this particular issue, Judge, obviously doesn't foreclose the state from proceeding under 1902b1. They still get to prosecute a murder if they so choose. It just means that if you're going to do it under b2, you got to tell them more. And if you can't tell them more, don't indict it that way.
Okay, and State, how do you respond to that last point on that case that says that's required?
Judge, you give me a brief moment.
I'll give you a brief moment, go ahead.
And Judge, I'll just add real quickly that if they do discover some act in the future, I expect they will amend or re-indict.
Hey, Judge, just to respond to DePaul, again, that analysis is a sufficiency analysis in DePaul. And it involves essentially looking back at the statute and determining if there is enough evidence to support an act of dangerous to human life. And that is an element that we look at through the trial. And that, again, is a sufficiency element, but it doesn't fix the issue that defense has of really not having a case that says that we're required to give that notice of more specificity than just saying an act of dangerous to human life.
In the Paul, the case is citing, you're saying there was a sufficiency of the argument case? I mean, I'm sorry, sufficiency of the evidence?
I can give the court a copy of the case, which I.
Let me look at it real quick.
It's reviewing the court's ruling on a motion to quash the indictment, starting at Penn site 633. Just for the benefit on, it's the second,
I can't hear you, I'm sorry.
just for the benefit of the record, second full paragraph on what is Bates numbered, page 5. Appellant argues in his first point of error that the trial court erred in overruling his motion to quash the indictment because the indictment language was both legally and factually, this is back when, before Brooks, when they made that decision. Legally
Is
and
your mic on,
factually.
sir, I'm sorry to interrupt you. Is your mic on? Is the green light on?
Yep.
Okay. I need you to pull it closer.
Sure.
Thank you.
Legally and factually insufficient to allege an essential element under the offense of murder. And the state's already conceded that the act itself, the act clearly dangerous to human life, is an essential element.
Judge, when you're ready, if you have a response.
Go ahead.
It's clear, in the paragraph that Mr. Gilmore cited, that this is a sufficiency review. That was the point of the error that was raised in this case. And when it gets to the point where they're discussing this, they say very specifically that the state's not required to plead their evidence in the indictment. What they do is they look at, in this case, there was an act alleged, and it was pled more specifically, and they look at whether or not that's sufficient. It doesn't follow from that we have to plead that, if that makes sense. It's a sufficiency review, and in addition to that, this is an Amarillo case from 1983, so it's not technically controlling or what that's worth.
Correct.
But I don't think it speaks to the point Mr. Gilmore's trying to make either.
Okay, and again, to you, counsel, Lugo, the authority kind of that you're citing is a concurring opinion that the majority in that case rejected, correct?
They rejected his analysis with respect to the requisite mental state for this offense.
Okay, now, anything else from either side?
Nothing to state.
Okay.
That's right.
All right, so first of all, since you've conceded, as you stated earlier, your motion to quash the indictment as to count 1, paragraph A, is denied, and the same thing with count 2 and count 3. Now, as regards count 1, paragraph B, the state had asked for more time to brief this issue. Do you still wish to have more time to brief this issue?
Judge, if you would allow it, we think we can provide the court with more case law on point.
Okay, so since that's the main issue in contention right now, I'm going to go ahead and hold my ruling in abeyance and give the state some time to respond. And as soon as I have their response to your last reply, I'll rule on that. So I'll hold my ruling in abeyance for now as to count 1, paragraph B. All right?
May I ask how much time the state has to provide a response?
Well, how much time do you need?
Yeah, a week, Judge?
Okay, 1 week. So give me a date. What's the date, Tuesday?
Yeah,
Next Tuesday? Whatever that day is, okay?
29th.
the 29th.
Okay, so we set for April 29th, 2025, at 9 a.m., just for that ruling, okay? Anything else?
Nothing from the state, Judge.
Okay, that closes the record in this case. Thank you.